I'd like to welcome you here this evening. My name is Rosemary Hayden. I'm here on behalf of the Irish Red Cross, and this is a collaboration between the Irish Red Cross and the Ukraine-Ireland Legal Alliance, hosted by the Irish Women Lawyers Association. Today, we have presenters from both Arthur Cox and DLA Piper, and the topic today is employment law. We'll ask everyone to leave your videos off and your sound on mute, and we will mute if we come across any. You can put your conversation, questions, or anything into the chat, and the chat will have all of the answers gathered together for you. So the topic we're going to have today, we're going to have an introduction. We're going to speak about the creation of an employment relationship. We're going to speak about what are your terms and conditions of employment. We're going to talk about a dismissal from employment, how that happens and what happens there, and how to make a complaint. So today we have our colleagues Ciara McDermott, Senior Associate at Arthur Cox, and Roisin O'Brien, Associate at DLA Piper. And I'm going to be handing over to both our colleagues for this presentation. So I'll simply be on the clicking a button, but our other colleagues are manning the chat. So any questions that people have either in English or in Ukrainian can be put into the chat, and we will address them either in the chat or in the Q&A at the end, or we'll be directing you to where you can get further assistance. So I'm going to pass over to our colleagues. I think it's Roisin O'Brien is going to be first. So thank you, Roisin.
Perfect. Thanks very much, Rosemary, for the introduction. And thanks everybody for joining. So myself and Ciara are giving the talk today on employment law. So I'll be starting off just by touching on the creation of an employment relationship and discussing certain protections that come with becoming an employee. So even before an employment relationship is created, there are rights afforded even at interview stage. And protection against discrimination is one of those rights. So in Ireland, employees' rights are protected by various pieces of legislation. There's the Constitution, EU legislation, statute, and case law. So in Ireland, the Employment Equality Acts is a key piece of legislation. So that protects against discrimination on the 9 protected grounds. So the 9 protected grounds in Ireland are gender, civil status, family status, sexual orientation, religion, age, disability, race, colour, ethnicity, and membership of a traveller community. So employers cannot discriminate in relation to access to employment. So that is like at interview stage. And the employers cannot discriminate against on conditions of employment, and that's including pay, training, promotion, or regrading of posts. So if you have been discriminated against as an employee, you can bring a claim to the Workplace Relations Commission. So that's the WRC mentioned below. So the WRC hears most employment cases in Ireland, and there's various awards you can get if you are successful. So those awards are compensation, and which is typically up to 2 years remuneration, depending on the claim. You could get an order for equal pay, an order for equal treatment, an order for the company to take a specific course of action, or if it is a discriminatory dismissal, there could be an order for reinstatement or re-engagement. So that's an order for you to go back to the company you were with before. So I just have a couple of interesting case examples that I thought I might read out and just kind of give a brief background on. So there was a case previously where a lady was at interview stage. And in the interview, she was asked, do you have children? Are you married? And how old are your children? So this was a discrimination claim at interview stage. And in that case, the employee was successful and was awarded €7,500 as it was held she was discriminated against on civil status. So that was whether or not she's married, and she was also discriminated against on family status. So that's whether or not she had children. So for discrimination at interview stage, the maximum award is 13,000. Another interesting case of age discrimination. There was a Ryanair ad previously where they sought a young dynamic employee, and that was held to be age discrimination. And just an example of a gender discrimination claim. There was a company previously who afforded female employees the right to get taxis home where public service was not available to them. This benefit was afforded to female employees only and not to males. And in that case, that was held to be discriminatory. So when you're bringing a claim to the WRC, there are certain things to be aware of. For a discrimination claim, there's no service requirement. So Ciara will speak later about the service requirement for an unfair dismissals claim. So you need to be in a company for a year before you can do that. But for discrimination claim, there's no service requirement. But your claim must be lodged within 6 months of the discriminatory act. And there are very limited exceptions where that can be extended. But I think a good rule of thumb is to ensure that your claim is lodged within 6 months. Okay, so that's that slide. If you want to move on to the next one. So just on the next slide is employment contract. So in Ireland, there are certain terms of employment that your employer must communicate to the employee within 5 days of commencement of employment, and other terms that must be communicated within a month. So in reality, what happens, most cases, what happens is employers will just have a general contract of employment, which will incorporate all the terms within the 5 days and within a month. So that's usually how employers will deal with that. So the terms that you must be notified to you within 5 days include the name of your employer and the address of the employer, the employee's name and the employee's address. You'll need confirmation as to whether the contract is fixed term or if it is a permanent contract. You will need confirmation as to your pay, the amount of it, and other components. So how often will you get paid? Is it a weekly basis, bi-weekly basis, or a monthly basis? Also within 5 days, you must be notified of your expected working hours. So whether or not that's 9 to 5, and your working days as well. So if you're meant to be working Monday to Friday, that should also be set out in the contract. Your place of work should be identified, and the general title and description of your work should also be included, the start date, hours of work, and if probation applies, this needs to be included in the contract as well. And then within a month, there's other various terms such as registered employment agreements, confirmation that the employee can request an average hourly pay, the frequency of paid leave entitlements. So I'm going to touch on that in a couple of more slides. These are family-based leaves, sick pay and pension entitlements, your notice period, any training entitlements, and for agency workers, the identity of the end user. And if the pattern of the work you do is unpredictable, then that needs to be confirmed to you. So if you're working on a roster basis or a shift basis, it will need to be confirmed that the pattern of the work is unpredictable. And just finally, then on that side, it says you will also need to be identified of the social security institutions receiving your contributions. So that's any taxes that are retained. So usually that'll be anything to revenue, such as PAYE, PRSI, and the USC. So that should all be contained usually in the employment contract and be confirmed within 5 days and 1 month. So just going on to the next slide. So after you receive your contract of employment, so you're consenting to the terms in the contract. So for an employer to amend those terms, there's kind of various approaches. So just on the next slide there, we'll set it out. So before your employer makes any changes, you must be notified of the changes in writing no later than the date they take effect. So there's some changes that are so material in your contract that you must consent to, and your employer cannot change unless they have your express consent. So material terms of contract would be like are your pay, your pay, your job title. So your employer cannot change them without confirming that with you. But there's other terms in your contract where the company has a little bit of flexibility. So that'd be like a work practice. So like the example that we're talking about on the previous slide, if there are changes to your roster or shift pattern, that's okay from a work practice perspective, provided that it's in line with the dates and times that were set out in your contract. Changes to duties, generally, as long as they're within the general title of what you're doing, that's all fine, and they don't need your express consent to do that. If there is a change by operation of law and the employment contract has to change because of law, then the employer doesn't need your consent for that. So an example of that could be recently, the statutory sick pay scheme came into effect in Ireland in the last few years. So many employment contracts before that said the company does not pay sick pay. Obviously, that has now all changed just due to new legislation. So for an employer to roll out the statutory sick pay scheme, it didn't need to obtain express consent from the employee on that basis because it was a change required by law. If your employer does materially change your contract without your consent, that's considered a unilateral change and it could amount to a breach of contract. So for such a claim, it would need to be so material to the contract, again, like your pay, your employer can't reduce your pay without your consent. So if your contract says you're entitled to 30,000 a year, the employer can't change that to 15,000 without your consent. And if they did that, this would lead to a very good constructive dismissal claim, which we will touch on later. But before you do that, it's encouraged that employees raise this with the company, bring a grievance before taking legal action. So that's kind of in a nutshell amending the employment contract. We're just going to go on to the next slide now. And we are on to terms and conditions of employment. And there is payment of wages. So obviously, payment of wages is key to your employment contract. All employees are entitled to be notified of their wages, a written statement of wages, contributions and deductions, and protection against unlawful deduction of wages. So there are sometimes contracts will reserve the right to lawfully make deductions to the employee. So you might see a contract that says if you take more annual leave than you are entitled to, then upon termination of employment, this will be deducted from your salary. But that must be set out in the contract for an employer to do that. And and in the contract, there must be a clause for you consenting to that deduction. But outside of any contractually agreed deductions, your employer must notify you before they deduct from your salary. There are minimum wage protections in Ireland. So the current minimum wage is £12.70, and this applies to all employees over the age of 18. Annual leave for full-time employees. All full-time employees are entitled to a minimum of 4 weeks annual leave. If you're employed on a part-time basis, these numbers will be slightly different depending on the hours you work. So an employee should give at least 1 month's notice where they're required to take, an employee should be given 1 month notice where they're required to take annual leave over a particular period. Oftentimes there might be closed down periods for Christmas, and employees are required to use annual leave for that, and usually that will be set out in a contract as well. And annual leave should be granted within the year to which it relates, or with the consent of the employer or employee within 6 months after the end of that year. So sometimes employers will let you carry over leave where you don't get to use it within that year, but that's always with the consent of the employer. So as we were talking about earlier, recently, since 2023, I believe, Ireland now has a statutory sick pay. So there are some eligibility requirements for statutory sick pay. So you must have worked in the company for at least a minimum of 13 weeks to be entitled to statutory sick pay. You must also have a medical certificate, and you will be paid at a rate of 70% of your normal wages, up to a maximum of €110 per year. So currently, the leave, you're entitled to 5 sick days, statutory sick days per year, and that's due to increase. So in 2025, that's going to increase to 7 days, and in 2026, that's due to increase to 10 days a year. But it's important that you meet the eligibility requirements in order to qualify for statutory sick pay. Okay, so perfect. We're going to go on to the next slide now, which is just in relation to alternative employment. So this sets out protections about part-time work, temporary and agency work, and zero-hour contracts. So there is legislation and protections for part-time workers in Ireland. So part-time workers cannot be treated less favourably than a full-time worker in respect of conditions of employment, so including pay and pension rights. And unless such treatment can be justified on objective grounds. So agency workers are entitled to the same basic working conditions as those that are there full-time. And there is a prohibition on zero-hour contracts in Ireland. So your contract must give you kind of an indication of the hours you're expected to work per week. So what is legally required in Ireland now is that the employer should give you banded hours. So where the employer may not know, they must give you the band. So for example, if they believe you could be working potentially 10 hours to 15 hours a week, that should be set out in the contract. And you cannot have simply a zero-hour contract where your hours vary drastically from week to week, and you're not kind of promised hours. So we're just going to move on to the next slide now. And so in Ireland, there are many kind of family protective leaves. So the first is maternity leave. So you must be an employee to be entitled to this leave. And you're entitled to 26 weeks, and that's kind of referred to as ordinary maternity leave. So during that time, you are provided that you have built up enough PRSI contributions, you are eligible to receive state benefit, and that's paid directly by the state. And I think at the moment that's approximately like €270. After that first 26 weeks, there's what's known as additional maternity leave, and during that time there's no state benefit available. There are other protections during maternity leave, so, or even when you're a pregnant employee at work. When you're a pregnant employee at work, you're entitled to attend medical appointments upon reasonable notice to your employer. You're entitled to attend prenatal classes as well. And during a period of maternity leave, this is considered protective. So your employment cannot be terminated during maternity leave. So say there's a redundancy at your workplace, your position cannot be made redundant on maternity leave. It's protective leave. And then moving on, there's also paternity leave. So this is currently a 2-week entitlement, Again, there are state benefit available during that time. It is quite common for some employers provided that you're with the company a certain amount of time, they may top up maternity and paternity leave. That is not a legal requirement. Some employers do it, but it's not a legal requirement. And then there's also parents' leave. So there's parents' leave and parental leave. These are different leave entitlements. So parents' leave is a leave available to employees where they have had a child and that child is age 0 to 2. So it's currently a 7-week entitlement. And again, there's state benefit available during this time. And that leave is due to increase to 9 weeks in August of this year. There's also parental leave, that's 26-week entitlement. And this differs from parents' leave in that the child can be up to age 12 or 16 if the child has a disability. There's adoptive leave. Again, this is quite similar to maternity leave. It's 26 weeks in duration. And for the first 26 weeks, you're eligible to receive state benefit if you qualify. And for the remaining additional 16 weeks, this is unpaid and there's no benefit available from the state. And there's also a carer's leave entitlement. So this entitles you to time off to assist with the full-time care of an individual. It doesn't have to be a family member, but the individual who needs full-time care must have a certificate from the Department of Social Protection confirming that they require full-time care. So that's kind of a summary of the protective leaves in Ireland. And with that, I'm going to pass you over to Ciara, and she's going to talk about dismissal from employment. And I'll happy to answer questions at the end. Thank you.
Great. Thanks, Roisin, and hopefully everyone can hear me all right. So to follow on from what Roisin mentioned at the front end in relation to terms and conditions that need to be set out in your contract, probation is one of those terms. Generally speaking, probation in your contract of employment should not exceed 6 months, and that's across the board. However, that period can be extended by your employer if there are exceptional circumstances, and in particular, if you're absent on sick leave, for example, there's a specific provision in the legislation that permits employers to extend your probation in line with the duration of any absence. So it's just something to be aware of. Apologies, my video is now coming on. Thank you, Rosemary. Another point just to be conscious of in relation to probation is if you are starting a very short-term contract with an employer, let's say it's 6 months in total, it would not be really considered proportionate to have a full 6-month probationary period. So that's something that you can push back on, and that should be tailored in line with the length or duration of your contract in full. So I'll move on to the next slide then, and that's to talk about dismissal from employment in Ireland, which sorry, apologies. So the basic general principle, I guess, is that an employer does have the authority to dismiss an employee from his or her business for whatever reason they want. That can be for a good reason or for no reason at all. And that can be on notice, which is either set out in your contract or in statute, or on reasonable notice if none is specified. So looking at this slide here, it sets out the minimum statutory notice that applies to all employees who work 18 hours or more per week. It increases in line with service. However, you will be entitled to receive the greater of either your statutory notice as set out here or the notice period that's in your contract. So very commonly, once probation expires, you could have a 1 month or a 3 month notice period, which is obviously longer than what you'll be entitled to receive under statute. An employer is obliged to give you that full notice period that's set out in your contract. Or if there's a specific clause in your contract, they can pay you in lieu, but they have to pay you in lieu of that full contractual period. So that's something just to be aware of. And so back to that basic general principle that I mentioned, there's the employer in that scenario has all the power, but under Irish employment law, it's very employee friendly. So we have a piece of legislation called the Unfair Dismissals Act. Under those acts, any dismissal or every termination of an employment is deemed to be automatically unfair unless the employer can show they have fair grounds for dismissal, and the burden of proof is on the employer in that context, unless it's a constructive dismissal case, which is slightly different. But the general rule is that all dismissals are deemed unfair, and it's the burdens on the employer to prove otherwise. You have rights under our unfair dismissals legislation as soon as you have 12 months service. So prior to that, it's much more difficult, and you may have to rely on a protected ground and claim discrimination. But as soon as you have 12 months service with your employer, any termination is deemed automatically unfair. And then the responsibility flips to your employer, and they will have to show that there are fair grounds for your dismissal. I'll move to the next slide, please. The potentially fair grounds for a dismissal are listed on the left-hand side. So capability, competence are generally related to performance or poor performance. So if you have a track record of failing to meet clear objectives, that must be documented, but you can be validly dismissed if there is a consistent record of poor performance and a series of disciplinary warnings or sanctions that have been imposed. Another reason that you can fairly dismiss an employee relates to conduct. That's really misconduct is what we're talking about there. So that misconduct might be theft, it might be repeated attendance issues, it might be long-term absence, unauthorized, it might be, failure to follow reasonable instruction at work. But if there are conduct issues, and I'll touch on this a little bit later, you must be awarded what we call fair procedures. So an employer cannot just automatically terminate you, even if they have cause. They have to follow a process and procedure to afford you your rights. Another fair reason often used that I've mentioned is a capability dismissal. So that will generally relate to your physical or mental ability to do the job that you've been hired to do, and usually will require a doctor's certificate saying, John has been in an accident and I don't feasibly see him ever returning to his full duties at work. And once that's in place, it's deemed fair for an employer to take the decision to dismiss you from employment. The other reason that's very commonly used then is redundancy. And I'll talk about that in more detail shortly. And then there is a final provision of the Act that states other substantial reasons, but it's very infrequently used because it's very hard to establish fairness in that context. So generally speaking, the employer will have a defense in cases where it's related to conduct, competence, capability, or redundancy, and otherwise they are potentially at risk. Again, noting that you must have the 12-month service requirement. However, as there are with all rules, there are exceptions. So if you don't have 12 months working with your current employer and they choose to dismiss you, there are 9 grounds where the dismissal will be automatically unfair. And those are the 9 grounds, discriminatory grounds that Roisin mentioned earlier: gender, civil or family status, disability, religion, race, colour or ethnic origin, sexual orientation, age, membership of the traveller community. Anything pregnancy related really falls under gender, but you can take it as an additional category. And if you have made a protected disclosure to your employer, if there's been a whistleblowing report and you feel that the employer has dismissed you as a direct result of that, that is also automatically unfair, and you don't need 12-month service in that context. So I might move on then to the next slide and just talk a little bit more about redundancy. So the laws in relation to redundancy are derived from a couple of different places: Redundancy Payments Acts, the Protection of Employment Acts, and the Unfair Dismissal Acts themselves. And a lot of our, I suppose, legal precedence comes from the case law and actual real life examples. So the first hurdle that an employer has to satisfy is that it has a genuine reason for a redundancy. So it can't just rely on redundancy as a fair ground for dismissal, call your dismissal a redundancy and get away with it. There has to actually be a legitimate reason. So if the employer ceases or intends to cease to carry on the business that you were hired to do in the place where you were employed. So let's say you work in a factory in Dublin and the employer is going to move that factory to the UK. That's a legitimate reason and a redundancy arises. If the requirements for the business for employees to carry out the work of a particular kind have ceased or diminished, or are expected to cease or diminish, that means if your factory's biggest client has moved elsewhere, and so the factory's output has decreased substantially, then there won't be so many orders to fulfill. The factory owner won't need so many workers, and therefore a genuine redundancy arises. Where an employer has decided to carry on the business with fewer or with no employees. So examples of that are where certain tasks, again, let's use the factory example, where certain tasks can be automated, say by a new piece of machinery or a robot. The employer might only now require 1 employee to operate the robot, whereas before there were 10 employees on a production line. That's a genuine reason for redundancy. Where an employer has decided the work for which the employee has been hired should be done in a different manner, and for which the employee is not sufficiently qualified or trained. So a business owner is entitled to make business decisions that affect their profitability. So if, for example, there's an employment lawyer in a firm and management decides that actually we don't need a specific employment lawyer, we need someone who can deal with employment law issues and with pension issues. I'm not qualified to deal with pension issues, and therefore I can be made redundant in a legitimate way. And then the last reason, fair or legitimate reason that a redundancy arises is where the employer has decided that the work for which the employee has been employed should be done by a person who is also capable of doing other work for which you are not sufficiently qualified or trained. So the example that I've just used again, so you've now got to be not only a solicitor, but you've also got to be qualified as an accountant in order to fulfill the role that we have in our business. I'm not an accountant, therefore it's a legitimate reason I can't fulfill the role, and someone else will have to be hired. So if any of those arises, a redundancy situation exists, and you can be terminated from your employment. However, where employers often fall down is in relation to selection. So to go back to the factory example, if there were 10 employees on a production line and the factory loses one of its biggest clients, but it has retained other clients, it might now need only 5 employees on that production line instead of 10. And in order to reduce the headcount, it has to run a fair selection process. The employer cannot just decide that John, Mary, and Sally are not very productive, we don't really like them, or they're from Ukraine, and so we're going to eliminate them first. They have to come up with a fair and an objective criteria and apply that to all 10 employees that are in the same or in a similar role. And from there, they have to select who will lose their job. So again, just something to be conscious of. Even if the employer has a legitimate reason, has it also applied a fair selection criteria? There are other more onerous steps that employers must comply with in relation to collective redundancies. Collective redundancies are usually where employers are making significant reductions in the size of their overall workforce. So the numbers depend on the number of employees that are engaged in total in a business. So there's probably a bit more for employers to be aware of than employees. But in a collective redundancy scenario, it just means there are more redundancies happening, and there's the opportunity to elect a representative who can engage with the employer and advocate on your behalf. Where a redundancy situation arises, in many cases, an offer of a lump sum or a redundancy payment will be put on the table for anyone who has 104 weeks continuous service with their employer, which equates to 2 years. If you have 2 years with the same employer, you are entitled to receive a statutory redundancy payment. That's something the employer has to provide to you legally. That's calculated as 2 weeks' pay for every year of service, plus 1 additional week's pay. But in that context, the week's pay is capped at €600. And your statutory redundancy payment is paid entirely tax-free. In addition to that, many employers will choose to offer an ex gratia or a lump sum on top, or in some cases, if you're not entitled to receive statutory, so if you've only got 6 months service, they might offer to pay just a token lump sum in order to have you sign some kind of waiver of claims. That will be standard practice, so I wouldn't be very concerned if that's the case. But just to be aware of what your statutory rights are in that context, to check. There's a redundancy calculator online that you can access on Google, and it's just really helpful to make sure you're being offered the correct amount. It's also important, if you're being paid in cash, to check that you're getting a pay slip and that those numbers are being run through payroll, so that you're technically on the employer's books. Because if you're not, and if you're made redundant, you won't be entitled to redundancy pay in respect of any days or hours that you were off books, unfortunately. Before I move on to making a complaint, and I'm slightly conscious of time, I might just mention again, in the context of any disciplinary sanction, particularly in relation to conduct or misconduct in Ireland, and in all cases where you're being dismissed from employment, there's a constitutional right to fair procedures by virtue of Article 40.1 of our Constitution. What that means really in practice is that before any disciplinary sanction is imposed, and or before a decision has issued to you that you're being terminated from your employment, the employer has to do a number of things. They're generally expected to have a disciplinary policy in place. That's a statutory requirement, so it's worth asking for that. They should invite you to a meeting in advance. They should set out clearly any allegations against you. So if it's a disciplinary meeting you're being called to, you're entitled to understand why that is. What did you do wrong? Did you punched John in the mouth yesterday and it's on CCTV. Okay, I'm entitled to know that. I'm entitled to see the CCTV. If someone has made a complaint about you, you're entitled to know who made that complaint and what it said. So you're entitled to be informed in advance of the issues or accusations. You're entitled to be represented at that meeting. What that means is you're entitled to bring someone. It's generally a work colleague. It's very rare that employers would let anyone else into a meeting. However, you might ask to bring a family member for support or who might assist with translation, for example. And you know, they can reject those requests, but you are entitled to be offered a right to representation. So even if that's a work colleague, it is really helpful sometimes to bring someone so there's an objective account of what occurs. Very often employees don't choose to do that, but it can be helpful. You have a right to put forward your own evidence or to make, I suppose, arguments in mitigation to say, okay, yes, I was late for work 4 days in a row, but the reason I was late was because, and the employer must take those arguments and rebuttals into account. You have a right, as I said, to understand who's making accusations against you. Anonymous complaints really won't hold a lot of water in the context of a disciplinary, and particularly if it's a serious sanction like a dismissal. And you're entitled to have an independent and impartial decision maker at the disciplinary stage. So let's say, for example, what I mentioned was, oh, you were caught in CCTV punching John in the mouth. If John is your supervisor, John cannot then run the disciplinary investigation or hearing, and John can't decide what the sanction will be. So that's just something else to be aware of. And then any sanction imposed also has to be proportionate. So to my earlier example, if you're late 4 days in a row and there's a reason for that, it's not necessarily proportionate or fair or reasonable for your employer to just dismiss you on that basis. It's a very different story if you've been late every day for 4 months consecutively. So just to bear those things in mind, I'm going to move on then to the next slide in relation to making a complaint. So as I mentioned, the onus is on the employer in relation to dismissal. They have to prove that a dismissal was fair. However, they also have, the employer in the context of a disciplinary sanction, a dismissal, or really any decision in relation to employees, they have to act reasonably, and the case law has set that out. So if you feel that they haven't acted reasonably, it is your right to take a complaint. Generally speaking, the best way to do that is to start off by making an internal complaint, which is often not the easiest or the nicest thing to do, but it does assist in reserving your rights down the line if you do take a legal case. So most employers will have a disciplinary policy, as I mentioned already, and will have a grievance policy. So if your employer, has a HR department, that's who you should ask to see it. If they don't have a HR department, I suppose you just ask your line manager or another member of management for a grievance process or procedure or policy, it might be called. And that document should set out what channels you should use to raise your complaint. This is the typical process we see. So there'll be the making of the complaint, and then once your employer receives that complaint, they'll hold a meeting or an investigation, it'll often be called. They'll generally bring a note taker, so another independent person, to write down the details of your complaint and any questions that are asked by the investigator. And then you will receive an investigation report or outcome in writing. If you are unhappy with that, you should have a right of appeal, and then the process almost starts again. Appeals generally will be so you might appeal on certain grounds. You can't raise your original complaint again, but you might say, I don't believe it was properly investigated because John was the manager who gave me the bad review in the first place, and that's why I raised a complaint. You would use your grievance process most commonly if you have an issue with the terms and conditions of your employment. So, for example, they've tried to change your working hours with very little notice, you would raise a grievance. If you are being bullied or harassed, that's usually a different policy. In some employers, it will not be. So just make sure you're asking for I suppose all of the relevant policies for making a complaint, and then you can decide which is the most appropriate. If an appeal is then not decided to your satisfaction, you have the option of making a complaint to the Workplace Relations Commission, and I think that's the next slide, please, Rosemary. Yeah. It's very easy to do. You can do it online on www.workplacerelationscommission.ie, and there's a blue button at the top of the screen. You click Make a Complaint. There's a drop-down menu, and you select the general nature of your complaint, what you think the legislation might be that it relates to, and then you just give a description of your story. You'll have to have your employer's full name, address, your own name and address. It's important to also know that those complaints will all be public. So if it does go to hearing, they can be published in the paper, for example. So some people are a little bit reticent when they hear that, but it's just to be conscious of. It's very informal when you make a complaint to the Workplace Relations Commission. Not in all cases, but it is possible for employees to run their own cases. There's a statute of limitations or a cap on the time. So if you run a grievance process at work and your employer says, no, I'm changing your pay and I'm not willing to consider anything else, and you want to make a complaint, you have 6 months to do that. There's only very limited circumstances where that 6 months can be extended, and you'll have to evidence the reasons for that. So I really would advise, if at all possible, to be conscious of that 6 month timeline. You'll receive a letter from the WRC, and an adjudication officer is appointed to hear your case, and it generally takes anywhere from 12 to 16 plus weeks to get a hearing date. You have the opportunity then to provide legal submissions or written submissions in advance of that. So some people will choose to have a solicitor, some won't. When you turn up on the day, it's up to you whether you choose to go alone or have representation, but you will be now sworn into evidence as you would in any court. So again, just to be aware of that. And any costs associated with the WRC are borne by you as an individual. So there's never any award. Even if you win your case, the adjudication officer doesn't have the power to say that the employer now has to pay your legal costs. So if you do decide to engage a solicitor or a trade union rep or whatever it is, and if there's a cost associated with that, that will be your burden, unfortunately. And then once a decision issues from the adjudication officer, you have 42 days to appeal that decision to the Labour Court. And Labour Court hearing is de novo, so they hear the claim from scratch as if it was a new case. And that generally, again, tends to happen slightly quicker, and they don't tend to be as busy, but it obviously depends on the volume of cases. And then from there, if there was a point of law to be argued after that, an appeal could go to the High Court, but that would be extremely rare and obviously more costly. So I'm going to stop now because I think there were some questions and I can see a lot of bubbles in the chat.
I think that's about it for this evening. We don't want to keep you too long, but we do want to say thank you all very much for your time. We very much appreciate your feedback, and have a lovely evening.